today's purpose of the class today is to talk about the French Protectorate. What we need to learn as Moors is following international law, which means you're following the instructions that's already been set forth. So as Moors, we have to get back to studying the law. Noble Ali told us to go to those who know law with an intelligent tone, and they'll give us a favorable response. So therefore, when you go to those who know law, you're talking about the international law. Because most times Moors find themselves fighting a debate or having a dispute with a different foreign state, which means the diplomatic document you have to use is international law along with your constitution. So today we're talking about one of the allies of the Moors, which is France, for the record. So let's take a look at some of the reference points, shall we? First things first, notice I have a flag up here. This flag is a flag that was ratified after the signing of the Treaty of Fez, F-E-S, Fez, F-E-S, that's commonly known as Fez, F-E-Z, of 1912. So the Treaty of Fez, 1912. So therefore, the flag that we're looking at now up here is in regards to France and the Empire of Morocco coming together in treaty. Okay? So they put together what's called a merchant's insignia, flag for their vessels, etc. And this is what it looks like. This is France's flag and Morocco's flag coming together. Okay, so everybody needs to know that for the record. This is what you call the material fact. Okay? Now, let's put a little history to this. All right? So as soon as the Treaty of Fez was signed in 1912, France went back to their consul, ambassadors went back to France. They publicized this announcement, and thereafter they went right over to the United States of America jurisdiction, extraterritorial jurisdiction, to announce the news to the United States of America, which they already knew, but France wanted to put it on the record with the United States of America because France has always been in an adversarial position with the United States of America. All right? So one of the things that we should take a look at now is this. It's called Morocco, the French Protectorate in Morocco, relinquishment of extraterritorial jurisdiction by certain foreign powers, attitude of the United States. This was in the year 1913. So as you can see, what I have written on the board right here is French Protectorate, i.e. Moors ally in the empire. See, protege. We're going to learn a lot about the word protege and what does it really mean. Protege is a Morse code, M-O-R-S-E, Morse code for saying Moors. Okay, you must understand that. It's synonymous with Moors. We'll learn more about that in just a moment. So therefore, what we're about to read is about the protection of Moors. Moors who don't have consular court representation because the Moors are what you call ipso jure Moor subjects. Why are they being called subjects instead of nationals? It's because of the extraterritorial jurisdiction that the United States of America was claiming over Moors, and they subjugated the Moors. Okay, so let's go ahead and read it for the record. This is the French Embassy, Washington, January 8, 1913. Mr. Secretary of State, by order of my government, I have the honor to communicate herewith to your excellency the text of the Franco-Morocco Protectorate Treaty that was signed at Fez on March 30th, 1912. Now this is France talking to the United States. The assurance of your excellency was pleased to give me heretofore as to establishment of the French Protectorate in Morocco led me to hope that the federal government will see no objections to giving its adhesion to that instrument. The French government would be glad to be assured. Your Excellency will note that under Article 6 of the aforesaid treaty, the diplomatic and consular officers of France will be in the charge of the representation and protection of Moroccan subjects and interests abroad. Who are the Moroccan subjects? Moors. Proteges, We'll learn about that. A limitation, however, was put upon the provision by the Franco-Spanish Treaty of November 27th, last of which I had the honor to communicate to the Department of State on the 29th of the same month. Article 23 of the treaty provides that the Moroccan subjects belonging in the zone of Spanish influence shall be placed abroad under the protection of the diplomatic and consular officers of Spain. So in Spain, they still had consular protections of Moors in Spain. So remember we talked about the William Dungy versus Joseph Spencer case? Yeah. And he said he was a Portuguese Moor, and Lincoln got him off. We'll talk about that another day, but that's the reason why. It's because there's certain protections of Moors. He said he was Portuguese Moor. Continue with the reading. The Secretary of State of the French Ambassador, Department of State, Washington, January 22nd, 1913. Excellency, I have the honor and acknowledgement the receipt of your Excellency's note of the 8th instant, transmitting the text of the Franco-Moroccan Protectorate Treaty, signed at Fez on March 30th, 1912, and asking adhesion of the government of the United States thereto, following the tradition of American foreign policy, which forbids participation by the United States in the settlement of political questions which are entirely European in their scope. The government must refrain from any expression or of opinion for or against such part or parts of the Franco-Moroccan Protectorate Treaty as may be deemed of a political nature. Paragraph 1 of Article 1 of the treaty provides that the government of the French Republic of His Majesty, the Sultan, mutually agreed to establish in Morocco such administrative, judicial, educational, economical, financial, and military forms as the French government may deem it desirable to introduce in Moroccan territory. And further, paragraph 2, Article 5 provides that the French commissioner resident shall be the sole intermediary of the Sultan in all foreign relations. By the term of Article 1 of the government of the French Republic practically assumes all the powers of government in Morocco, and as a neutral polarity thereto assumes also the obligations of the Moroccan government in its relations with foreign governments insofar as existing treaties rights between Morocco and foreign governments are concerned. So he's talking about France is a power move. They're telling the United States, we got power over you because we got power over all treaties that Morocco has in the United States of America. They're the protectorate. Okay. As your Excellency is aware, adhesion on the part of the government of the United States to any treaty under our Constitution can only be given by and with the advice and consent of the United States Senate. And after careful consideration of the Franco-Moroccan Protectorate Treaty, this government is of the opinion that it is not sufficiently detailed and concrete in its provision to permit of submission of this country's treaty making power. So what is the United States doing? They're saying objection, even though a treaty's been signed. They recognize France just made the United States subjects. France made United States subjects because they're protecting Morocco. Let's continue. Provided, however, the government of the French Republic is willing to give an assurance that American interests and rights in Morocco, remember, United States of America is in Morocco, as are a present safeguard by existing treaties, shall continue to receive the same considerations in the future as they have been entitled to and have enjoyed in the past. On such an understanding, the government of the United States will be inclined to view with favor the reforms which the French Protectorate contemplate introducing into Morocco and providing for the treaty in question. So what are they doing? They're trying to say, hey, France, let us just maintain this subjugation of these Moors here. Just keep everything the way it's been. The French charged the affairs of the Secretary of State. Continue to read. Mr. Secretary of State, By order of my government, I have the honor to forward herewith to your excellency 2 copies of the official bulletin of the Morocco Protectorate promulgating the new judiciary system in the French zone of the Sharifan Empire. Sharifan Empire means the Moorish Empire. Together with a copy of the Journal Officiel of the French Republic of September 9th, 1913, which also contains a decree relating to that organization. In other words, they made it public record. The new judiciary system, I say again, the new judiciary system, instituted by virtue of the provisions in paragraph 2 of Article 9 of the Franco-German Treaty of November 4th, 1911, is intended to supersede the French Consul courts on after October 15, 1913. In accordance with the provision of the aforesaid Article 1, have been instructed to ask the federal government to place its citizens under the new jurisdiction. I shall hasten to forward to my government the reply your excellency will be so good as to return to me on the subject. Continuing to read. Excellency, the department has the honor to make the reply to the embassy's notes of August 29th, September 14th, October 7th, and January 7th last, relative to the establishment of the French Protectorate in Morocco and the revision of the list of American protégés in that country. They wanted a list of Moors. That's what France was demanding. Because if you go back and look at the Treaty of Madrid, 1880, it talks about the United States had agreed to give a list of Moors. We'll talk about that another day. So right now, France is saying, where's that list that you agreed to in 1880? Keep in mind now, this is 1913. Let's continue. In the first note above mentioned, the department is informed in relation to the establishment of the French Protectorate that owing to the adequacy of the means thereto employed to prevent the smuggling of arms and munitions of war into Morocco, generally Ante had decided to declare martial law within the zone of French influence in Morocco in the matter of contraband of arms. In the informal note of September 14th, Mr. Protectorate, who was then acting as charge d'affaires ad interim, made known the wish of his government that the government would give instructions to its representatives at Tangier, looking to the designation of a delegate to assist in the revision of the protection list of people lying under American jurisdiction. Talking about that list of who? Moors. The protégés. Who are the protégés? Moors. Ipso jure Moorish subjects, to be specific. Right. Let's continue. Mr. Protectorate added that it was not possible to accept the reserve of the United States relative to the right of foreign representatives to act in last resort upon the decision of the Magazine. In regards to the natives who should enjoy the protections of a foreign government. I'll read it again. In regard to the natives who should enjoy the protection of a foreign government. Who are told the natives? Moors. With this note of October 7th, Mr. Protectorate transmitted to the department copies of the official bulletin of the Morocco Protectorate promulgating the new judiciary system in the French zone. What's the French zone? Moorish Empire. Of the Sharifan Empire, Moorish Empire. See how you're putting the two together now? Mr. Protectorate called attention to the fact that the new judiciary system was intended to supersede the French consular courts on and after October 15, 1930. And under instructions, asked this government to place its citizens under new jurisdiction. Finally, with your note of the 7th of January last, you transmitted to the department a list of errata in the bulletin official and requested that the new French courts in Morocco be recognized at the earliest possible date, turning first to the subject of revision of the protégés list, Sidiona, the Moorish list, mentioned in Mr. Protectorate's note September 14th in the proper to state. Continue the reading. That the protection of native Moors, he just said it, in Morocco by the government rests upon its treaty with Morocco of 1836 and the Madrid Conventions of 1880, relevant part of the Treaty of 1836 is found in Article 15, which reads as follows. You see what France doing? They're pulling up these treaties. So therefore, merchants of both countries shall employ only such interpreters and such other persons to assist them in their business as they shall think proper. The Convention of 1880 declares in Article 1 the protection of native Moors. I'll say it again. The Convention of 1880 declares in Article 1 the protection of native Moors. I'll say it again. The Convention of 1880 declares in Article 1 the protection of native Moors is based on the British and Spanish treaties with Morocco and on the Convention of 1863 between France, Morocco, and other powers, with the modification introduced by the present convention and stipulations in Article 16 that the authorities of Morocco will recognize no protection of any kind whatever save such as expressly provided for in this convention. After a careful examination of several articles of the Madrid Convention relative to the protection of American protégés, they already told you who the protégés are, didn't they? The native Moors. So protégés is a Morse code they use. The department is unable to reach the conclusion that the Moorish government enjoys the right ultimately to decide upon the persons who may become protégés of this government. What government?
French.
On the contrary, Article 2 of the Convention provides the foreign representation at the head of the legation may select their interpreters and employees from among the subjects of Morocco or others. Who's the subject of Morocco? The ipso jure Moorish subjects. And Article 3 provides that the consular officers shall be allowed to select their employees, because that's in the Treaty of Madrid. They call them employees, an employee list of Moors. By Article 5 of the same convention, the government of Morocco recognizes the right of ministers, chargé d'affaires, and other representatives, which is granted to them by treaties to select the person whom they employ. In regard to this list of protected persons, the convention is equally precise, as appears by Articles 7 and 8, which read as follows. Article 7. Foreign representatives shall inform the Sultan's Minister of Foreign Affairs in writing of any selections of any employee made by them. They shall furnish annually to the said minister a list of names of persons protected by them or by their agents throughout the states of the Sultan of Morocco. This list shall be transmitted to the local authorities, who shall consider as persons enjoying protection only those whose names are contained therein.
Diplomatic community.
Article 8. Consul officers shall transmit each year to the authorities of the district in which they reside a list, bearing their seal of the persons protected by them. These authorities shall transmit to the Minister of Foreign Affairs to the end of that. If it be not comfortable to the regulations, the representatives at Tangier may be informed of the fact. A consular officer shall be required to give immediate information of any changes that may have taken place among the persons protected by his consulate. Regarding the appointment of protégés for signal services, the convention provides Article 16 that the Minister of the Foreign Affairs at Tangier shall be previously informed of the nature of the services and notified of the intentions to award them, in order that he may, if need be, present his observations thereon. Yet the final decision shall be reserved for the government to which the service shall have been rendered. Concerning the protection of native employees of private persons, the Treaty of 1836 appears to contain no stipulations. But in Article 9 and 10 of the Convention of 1880, there are found the following provisions. Article 9. Servants, farmers, and other native employees of native secretaries and interpreters shall not enjoy protection. The same shall be the case with Moorish employees of service of foreign subjects. Nevertheless, the local authority shall not arrest an employee or servant of the native officer in the service of legation or consulate, or a foreign subject or protected person, without having notified the authority upon which he is dependent. if a subject of Morocco in the service of a foreign subject shall kill or wound any person or violate his domicile, he shall be arrested immediately, but the diplomatic or consular authority under which he shall be notified without delay. Article 10.
Consular notification.
That's consular notification access. Nothing is changed with regard to the situation of brokers as established by the treaties and by the Convention of 1863, except what is stipulated relative to taxes in the following articles. Insomuch as Madrid's convention refers in Article 1 to the Convention of 1863 between France and Morocco and the powers regarding the protection of native Moors, and the British and Spanish treaties with Morocco on the same subject, it is approximate to examine the provisions of these treaties on the subject. The provisions of the Convention of 1863 appear to be substantially the same as the regulations relative to protections adopted by common consent by the legation of France and the government of Morocco, August 19, 1863, reprinted in treaties in force 1904 at the end of the Madrid Convention. The regulations are in part as follows. Protected persons are divided into two classes. The first class comprises natives employed by the legation and by the various French consular officers. The second class consists of native factors, brokers, or agents employed by French merchants for their business affairs. French protection is not extended to natives employed by French citizens in agricultural occupations. It is, moreover, understood that the agricultural laborers, herdsmen of other native peasants in the service of French citizens shall not be legally prosecuted without immediate information thereof being communicated to the competent consular officer in order that the latter may protect the interests of the countrymen. The list of all protected persons shall be delivered by the proper consulate to the competent magistrate of the place, who shall likewise be informed of any changes that may be subsequently be made in the said list. Each protected person shall be furnished with a card in French and in Arabic mentioning his name and stating the services which should secure this privilege to him. All these cards shall be issued by the legation of France at Tangier. Passports, etc. The British and Spanish, let's just stop there for a second. Why is France saying this? Because they know the United States ain't been keeping up with the list. So if you're not keeping up the list, then how can you identify who should be on the list and who shouldn't be on the list? See how they're cornering the United States of America off? You ain't kept the list, then you can't make a distinction. So everybody now should be grouped together to say they're protected. Because you never came up with a list of protected, subjugated Moors. You see the game they're playing? It's strategic. Listen, the British and Spanish treaties mentioned in Article 1 of the Madrid Convention are presumably the General Treaty of December 9, 1856, between Great Britain and Morocco, and the Treaty of Commerce and Navigation of November 20, 1861, between Spain and Morocco. In the British treaty is specifically provided that the charge d'affaires and the consular officers of Great Britain shall be at liberty to choose their own employees, and the British subjects shall be free to commit their affairs to the management of any person whom they may appoint as their broker, factor, or agent, nor, says the treaty, shall such British subjects be restrained in their choice of persons to act in such capacities. The Spanish treaty provides that the charge d'affaires or consul general may choose his interpreters in service from amongst the Muslim men subjects. The Muslim men subject. Who's the Muslim men subject? Moors. Of amongst those of any other country, that other consular officers may name employees, either Muslims or subjects of another country, and that Spanish merchants may put their affairs into the hands of brokers or agents appointed by themselves, and they shall not be interfered with, nor shall obstacles be raised to the free choice of the person to fulfill this charge. It would therefore seem that the choice of the protégés of the United States in Morocco, I'll say it again, it would therefore seem that the choice of the protégés of the United States in Morocco rests right of treaty ultimately with this government. Such appears to be a view which the department has always taken of the Convention of 1880, and which has been the basis of its actions as carrying out provisions of that convention. The question of choice of proteges is, however, in the view of this government, but a phase of a larger question involved the establishment of French and Spanish control over separate portions of Morocco. On the subject of French protectorate, this government has heretofore expressed itself as being in favor of the reforms which France contemplated introducing into Morocco in accordance with the stipulations of the Franco-Morocco Treaty of March 30 of 1912, of the understanding that provisions be made for the preservation of American interests and rights in Morocco, commercial otherwise, which are at present safeguarded by existing treaties with that country. The more important of those interests and rights it is proper now to enumerate, thank you, good brother, enumerate. In the first place, attention may be drawn to the right of aliens to hold land in the Sharifid Empire. Now listen, now he's going to flip the conversation. Now he's talking about aliens holding land in Morocco. So who is he talking about? United States of America. This right appears now to be based upon provisions of the Madrid Convention and the Algeciras Act, with a view to carry out Article 60 of the Algeciras Act. The Sultan's foreign minister on December 5th, 1912, sent to the diplomatic corps at Tangier a set of regulations classifying the public domain of the empire and defining inalienable property and unalienable property. These regulations also laid down certain rules to govern the sale of latter class of property to foreigners. So France is making power moves. He's attacking the real estate, which means he's attacking the estate, because the word real estate is made up by foreigners and aliens, i.e. United States, who are chiefly British. So France is now challenging their what? Mortgages. Remember, mortgage didn't come out to the early 1900s? Mortgage is a French word for dead pledge. It is understood that these regulations are not entirely consistent with the provisions on the subject of land ownership and the Act of Algeciras and the Convention of Madrid. Under Article 11 of the Madrid Convention, the right of all foreigners, quote unquote, to hold property, quote unquote, anywhere within the empire is recognized. See, they're holding, these people call themselves United States citizens, i.e. white people, quote unquote, or the applied term American, quote unquote. They're holding land in the empire with mortgages and deeds, which are not by law ownership, it's only possession. And that possession only comes by permission of the Moroccan government. If you don't get permission from the Moroccan government, you can't even have possession or ownership. Let's continue. It is understood that the regulations are not entirely consistent with the provisions of the subject of land ownership in the Act of Algeciras and the Convention of Madrid. Under Article 11 of the Madrid Convention of the right of all foreigners, quote unquote, to hold property, quote unquote, anywhere within the empire is recognized. But the purchase of property must take place with the provisions consent of the government. By Article 60 of the Algeciras Act, the right was confirmed, and it was further provided that within a radius of 10 kilometers around the open ports and within 10 kilometers around certain other towns, land might be acquired by foreigners without the provisions consent of the Moorish government. The proposed regulations define inalienable property, quote unquote, to include the guiche, quote unquote, lands, the seahorses, habits, quote unquote, or mosque properties, tribal lands, forest lands, desert, uncultivated or ownerless lands, or bearing land, and its ceded property. The department is advised that practically all the land within the 10-kilometer zones, especially at Tangier, is either guiche, quote unquote, land of seashore, land or seashore. Consequently, there would appear to be little or no land lying within the 10-kilometer zones which may be subject to private ownership without the consent of the Moorish government. Moreover, while in one paragraph the regulations recognize the fact that under Article 60 of the Act of Algeciras, no authorization is necessary for the sale of lands within certain zones. In the next paragraph, the regulations provide that the Cadi will approve no sale made to foreigner unless the authorization according to the regulations has been granted by the Moghzin. A Moghzin is, that's your federal government officials, etc. It would seem therefore, that in the regulations are correctly understood, an interpretation has been given to Article 60, which its terms would not ordinarily bear. By the same regulations, the Moroccan government reserves the right to annul or to revise, quote unquote, any deeds of so-called inalienable property, which may have been given prior to the date of the regulations. The department is advised that much of Guiche and seashore property, as well as other lands situated within the zones above mentioned, has long been held by private individuals under deeds, legally obtained with the authorization of the responsible agents of the Moghzin. So who are they talking about? The United States of America has deeds and mortgages, but they don't have a Allodium title. So they're making a false claim of property in Morocco. Let's continue. In the view of the circumstances, it is difficult to believe that it is the intentions of the Moroccan government to consider these regulations as retroactive in their operations and is thereby divesting of giving opportunity to divest rights in land legally acquired and officially confirmed by the Moghzin's agents. The proposed regulations, as understood by the department, further provide an effect that no transfer of land will be authorized until the different Moorish intermediaries have stated that no government rights are infringed. So who are they talking about? France making a power play. Y'all can't do nothing without France permission. Who's the they? United States of America. The provision probably has in view the carrying out of that part of Article 60 of Algeciras Act, which stipulates that before authorizing execution of deeds transferring property, the Cadi will have to satisfy himself of the validity of the title in conformity to the Mohammedan law. The department is, however, advised that the records of land titles in Morocco are very incomplete, and that this provision of the regulations may be used to delay indefinitely transfers of property in which the Moorish government has in fact no legal or equitable rights. As a further restriction upon the right of land ownership, it is reported that, notwithstanding the provision of Article 60 of the Algeciras Act respecting the acquisition of land within stated zones around the open ports in certain other towns, the Sultan, about a year ago, issued 2 decrees imposing military servitude upon land situated within a radius of 250 meters around towns and fortified quarters within certain enumerated districts. It appears that certain havas or mosque properties are alleged to have been irregularly disposed of in the past to persons subject to foreign jurisdiction, who hold these properties either without regular title thereto or by virtue of doubtful contracts. The Algeciras Conference took formal note of this situation, and by Article 63 of the Algeciras Act, charged the diplomatic body at Tangier to solve these questions equitably in accord with the special commissions whom His Sharifan Majesty may be pleased to designate to that effect. This stipulation does not appear to have carried out. On the contrary, the department is informed that the Sultan has communicated to the diplomatic corps a circular proposing measure for the recovery of such properties. In these circumstances, it was seen that title to the land already acquired and the right to make acquisitions in the future are being called into question and placed on an uncertain basis. The government is therefore desirous of some assurance that the vested rights of its citizens and proteges in property in Morocco will be respected, and that the end will be promptly confirmed by the Moroccan government, and that the existing treaty rights respected the purchase and sale of land within the empire will be protected and preserved. In the second place, the department ventures to mention the subject of trade discriminations practiced by the authorities in Morocco. Complaints, apparently well-founded, have reached his government that customs duties have been imposed arbitrarily and without uniformity, that the unreasonable export duties of surcharges have been collected, and that free and open competition and binding for construction of public works or the furnishing of supplies for the government have been denied. It is reported that customs duties on imports of the vacuum oil company vary for different ports of entry and for different countries of origin, thus in practical effect working on a discrimination between importers at the same of different ports. For example, it is stated that in the recent past, the customs duties have varied from 5.50 francs to 6.50 or 7 francs per case. The department is also informed that in 1911, exporters of olive oil in barrels from Mogador, Morocco to New York were arbitrarily made to pay 14 pesetas surcharge as tare on the barrels, regardless of the offer or desire of the exporter or his agent to empty a sample barrel for the purpose of determining the exact tar or tare for the shipment. It is understood that Articles 105 to 110 inclusive of the Algeciras Acts require free and open competition without preference of nationality, and bidding on proposals for public works and supplies for the Moroccan government. The department is advised, however, that specific proposals are not always prepared so that the real competition is possible. It is stated, for example, that the specifications do not always disclose the rate of duty on materials, machinery, and tools, so that the distinct binders, unacquainted with local conditions, are placed in a great disadvantage in formulating bids. It is understood also that the opportunity of foreign contracts to take part in competitive bidding is minimized by the method of dividing large government contracts into allotments to small to attract any but nearby contractors. As the main purpose of the United States has participated in the Algeciras Conference and an adoption of the act resulting therefrom was to preserve and increase its commerce in Morocco, this government desires equal opportunities for American commercial interests, not only to maintain their present standing in Morocco, but also to share in the country's commercial development. In the third place, the department is advised that a commission composed entirely on French nationals has been appointed for the liquidation of outstanding claims against the Moccassin. Notice of this commission and of the date for presentation of claims has been communicated to this government and to American citizens and protégés in Morocco. The department is not at present advised to the extent amount of the claims so far presented, but it is to believe that the sum approximates $150,000 US. It is also understood that the certain wards made by the Claims Commission, which sat in 1910 for the purpose of considering the claims of aliens against Moccasins, have not as yet been fully paid. The government, therefore, is desirous that the awards of the Commission of 1910 be duly paid to the American claimants, and that some assurance be given that the awards of the present Commission will be paid within a certain reasonable period. Finally, it is perhaps proper to mention the case of Jacob Bonatul, an American citizen, who has some years been engaged in litigation before the Moorish courts in the manner provided in the Treaty of Madrid, in an effort to secure the restoration of a strip of land said to have been arbitrarily taken and used for a highway. It appears that the property of Bonatul bordered on the roadway, and that certain persons of foreign nationality, including Frenchmen and Spaniards, who owned land on the opposite side of the road, erected buildings beyond their property lines and thereby caused the roadway to encroach upon the land owned by Bonatul. in the course of litigation, Benotol obtained a judgment in his favor by the Shara, which on appeal, as provided by treaty, was confirmed by the Sultan's foreign minister. Therefore, the Consul General of the United States, according to custom, requested the Moorish authorities to enforce the judgment, but they never acceded to the request. The only legal course that opened to the American claimant was for him to sue upon the judgment in the consular courts of France, Spain, and the other countries whose nationals were concerned. It is doubtful whether such a course would have been proved effective, insomuch it is understood that defendants would, in the event of decision adverse to themselves, have had the right to appeal to the superior home courts of their respective countries, as the expense involved in such proceedings was prohibitive to the American claimant. The department has long desired that this case, which has been a source of misunderstanding and diplomatic correspondence for many years, should be disposed of by settlement between the two governments. The foregoing statement covers the more important matters under discussion between the government and that of Morocco. There are other matters which have been given rise to diplomatic correspondence, but they may be reserved for future discussions if need be. The present review embraces matters that touch the maintenance of American commercial interests in Morocco and the protections and liberty and property of American citizens and protégés in that country, and is also for the purpose of removing any points of controversy in these particulars and bring about an adjustment of them, that the government animated for the favorable disposition towards the reforms which the French Protectorate is designed to assure, has already itself to an exposition of the question as to which it desires to reach a definite understanding and settlement, as a preliminary to our incident of the recognition and due of the proper form of fundamental change involved in the establishment of foreign government regime in the Sharifan Empire. In conclusion, it may be proper to call attention to the situation the American missionaries in Morocco. These missionaries have for years labored in this field, including the districts inhabited by the Berber tribes, and as the department is advised, have maintained and continue to maintain friendly and mutual satisfactory relations with the authorities of the country. They have expressed themselves as most appreciative of the courteous and kind treatment accorded to them by the French officials in Morocco. This government therefore ventures to express their earnest hope that in any recognition of the government of the empire, which may be contemplated or in progress, the rights and privileges of these missionaries may be carefully safeguarded, and every facility be granted to them for prosecution of their worthy, benevolent task. Mr. Secretary of State, referring to the oral communications by which I made known to the Department of State the views of the government in respect to remarks contained in Your Excellency's note of February 13th last about Morocco, so now he's talking about the United States being in Morocco, I have the honor and compliance with instructions I have received to remind you of the high value we should attach to the United States government relinquishing, together with its consular courts, its extraterritorial privileges in the French zone of the Sharifan Empire. You got to see that France, the United States, was already talking about the United States relinquishing jurisdiction in 1913. Your Excellency notes above mentioned held out the prospect that the United States would accede to our request and record its accession in due and proper form, but pointed out a certain number of topics as to which favorable assurances were requested. As to the matter of form, my government wishes me to submit Your Excellency the enclosed draft of declaration which in its opinion fits the situation that is to be cleared. I am told that the declaration has already been signed by the Russian and Spanish governments and that other adhesions are forthcoming. As to the several points mentioned in Your Excellency note, I may, as I have already done by my word of mouth, assure you that the government of the Republic is quite ready to settle in the most friendly spirit the questions of interest to the United States in Morocco that may still be pending. Among these, that of the protégés, Moors, naturally ceases to be of any practical importance to the powers that agree to recognize our new courts, the tardive tax being besides already paid by foreigners. As to the right of aliens to own real estate, i.e. United States of America citizens, it has not been restricted by any Sharifan regulations. All that has been done was to take a few urgent measures having relations to strategies of promoted by the necessity of checking speculations in land intended for public use. The complaint of the vacuum oil company against the custom treatment according to the products had not been brought by the party. Consider the representative of this country the notice of my government, which deems it is duty to respect, to recall that the treaties of force guarantee equal physical treatment to all the powers, and that they may be assured that nothing will be overlooked to let their nationals enjoy the full benefit of those advantages. My government indulges the hope that under the conditions I have just brought to mind, and in view of its firm intentions to examine and settle in an entirely friendly way the few questions that unsettled in which American citizens are interested, Your Excellency will kindly concede in the views I have just had the honor to submit to you. Your acceptance of these propositions will be particularly gratifying to the government of the Republic, which would take it as fresh evidence of the traditional friendship existing between our two countries. So, we'll just continue to read. The undersigned, duly authorized by the respective governments, making common accord the following declaration. Taking into consideration the guarantees of juridical equality offered to foreigners by the French courts of the Protectorate, the government of the United States relinquished all claims for its consuls, persons subject to its jurisdiction, and its establishments to any right or privilege derived from the regime of the capitulations. The treaties and conventions of every nature enforced between France and the United States cover, as of right, unless otherwise stipulated, the French zone and the Sharifan Empire. This declaration will go into effect 10 days after its date. So what just happened? The United States agreed to give up relinquished jurisdiction over Morocco right then and there.
Yeah. But was it signed?
But it was a declaration, just a verbatim, but it was most likely never fully ratified. But we'll learn about that more.
Because it doesn't say it was signed.
Correct. It was what they said on the record, but it actually needed to be fully ratified. Excellency, I have the honor to inform Your Excellency that the Department, in receipt of the telegram from the American chargé d'affaires at Tangier stating the French diplomatic agent in the city in the name of French Resident General had requested of him a memorandum of pending and unsettled claims, and understanding that this government would not be favorably inclined to recognize the French Protectorate until those cases were satisfactorily disposed of. So what do? We got to tie up some loose ends. Whatever was going on, they're trying to tie up some loose ends before the United States would agree to anything. The American legation at Tangier has been instructed to submit to the proper French authorities a memorandum of all pending American claims in Morocco. And I beg to assure Your Excellency that the satisfactory solution of these cases will greatly aid this government in replying to your note of January 8, 1913, containing the request of your government for formal recognition of the French Protectorate in Morocco. Now, you see these dates, right? January 8, 1913. Who came on the scene around these dates? Noble Drew Ali. Right? 1913. Mr. Secretary of State, my government, in which I did not fail to forward the contents of Your Excellency notes of February 13th, April 30th last, about the doing away with the extraterritorial rights in the French zone of Morocco and about certain claims of the American citizens has just affirmed to me that it had promptly taken steps to bring about, under the most equitable conditions, a settlement of those claims. In regard to one of them, that the vacuum oil company, my government, which had never heard of it, wrote to Morocco to inquire about the grievances the concern might have to state as the customs treatment is received. General Liate accordingly called upon the agent of the company for explanations. The answer was that he had not slightest ground for complaint against the customs authorities. As for the other claims, the instructions sent by Your Excellency to the representatives of the United States at Tangier have no doubt brought to your knowledge with all the needful explanations that the facts from which those claims may have arisen. I beg leave in this connection to refer to the note I had the honor to address to Your Excellency on the 22nd ultimo April, in which, while answering the main points mentioned in your note on February 13th, I laid stress on the importance attached by my government to the government of the United States' earliest possible accession to the request I had laid before you. I am informed by my government that Russia, Spain, and Norway have already renounced their extraterritorial rights by signing a declaration like that enclosed my above-mentioned note. Other accessions are prematurely expected. Mr. Secretary of State, in the course of negotiations for the suppression of consular courts and extension of extraterritorial rights in the French zone of the Sharifan Empire, it was occasionally objected to the representatives of the Republic that it was not possible for the powers to take any further responsibility in the fate of their Moorish protégés. Fate of their Moorish protégés. See, they just put protégé and Moorish together? Mm-hmm. There would seem to be some foundation for that feeling. In fact, on the provisions of Article 12 of the Franco-German Agreement on November 4th, 1911, whose full scope is given in the explanatory letter, the government of the Republic would certainly have the right, after the discontinuance of the consular courts, to ask that the protection be done away with. The strict legal effect of this would be to place under native jurisdiction the protégés who, under the president's system, are enjoying consular jurisdiction, but with the view of obviating the hardships that might thereby be brought upon the Moorish subjects, thus deprived of protection. So Moors have been deprived of protection. Who else said that the Moors were deprived of protection? Mr. Root, of the 1906 Citizens Abroad expatriation, he said about the Moors didn't have protection. You see how that's coming back to the conversation in 1913? We'll talk about that another day. But with a view to obviating the hardship that might thereby be brought upon the Moorish subjects thus deprived of protection, the government of the Republic is already to declare them to be, as long as they live, under jurisdiction of the French courts set up in the Protectorate. I'll say it again from the top. But with a view to obviating the hardships that might thereby be brought upon the Moorish subjects, thus deprived of protection, the government of the Republic is ready to declare them to be, as long as they live, under the jurisdiction of the French courts set up in the Protectorate. This will place them, in this respect, on an equal footing with the persons subject to the jurisdiction of the former protecting power, and not with the natives. My government authorizes me to make its intentions as to this known to the federal government, being convinced that they are likely to remove any apprehensions concerning its protégés, if after availing itself of the rights conferred upon it by the existing provisions, the government of the Republic should procure the abolition. I avail myself of this opportunity to enclose 3 copies of the Louis Renault's preface to the codes and laws enforced in the French Protectorate in Morocco, which brings forth the value and importance of legislative work of the Protectorate, showing as it does the guarantees extended to all foreigners in Morocco that paper ought to be expedite adhesion to the new system on the part of the few powers that have not yet relinquished the exercise of consular jurisdiction. Mr. Secretary of State, by a letter dated February 13th, last, Mr. Bassett Moore made known to the embassy that the federal government's intentions respecting the acceptance of the jurisdiction of the new courts instituted by us in Morocco for persons subject to the American jurisdiction. At the same time, Mr. Bassett Moore expressed a strong desire to arrive at settlement of various questions affecting American interests in the Sharifan Empire. See, they're meeting right there. They're in the Moorish Empire. The resident Commissioner General of the French Republic, to whom the State Department's note was afforded by Minister of Foreign Affairs, was returned to Mr. Viviani, or Viviani, something like that.
Viviani, you said.
Viviani, an answer that substance in which have the honor to communicate to you, with the exception of two clearly defined cases, Vacuum Oil Company and the Benatul case, which will be fully explained hereafter. The federal government formulates, but does not specify, reservations or demands of purely general character against the Protectorate government. There is no question about the federal government being as much as any other warranted in watching over the economic rights and interests of Morocco, which, as put by Mr. Bassett Moore, are safeguarded by the treaties included between the foreign powers and the Sharifan Empire. But it's equally true that the Protectorate government is bent on respecting to the fullest extent in favor of the Americans as well as all other foreign citizens or subjects the principle of economic equality. The principle being once more evoked, the reservation or claims put forth by the federal government are so general in their character that, from the fact that the importance of American interests and the number of persons lying under American jurisdiction appear to be out of proportion to the set of reservations and objections offered, the question arises where Mr. Bassett Moore's letter of February 13, 1914 is not aiming after all, and while the federal government expressed itself in favor of the reforms to reopen the question of a very principle of the Protectorate regulations powers. As a matter of fact, it does not seem possible to maintain the protests that have been made against the Protectorate government upon the careful examination of everyone of the questions presented. 1. As regards the contemplated martial laws, cases, contrabands of arms, the matter having been settled by dropping the subject needed not to be brought up anew. So what I'm going to do is I'm going to stop right there because they're about to get into other different subject matters.
Okay.
The purpose of the reading today is that we all understand that France has an obligation to the Moroccan Empire to be the protectorate. The protectorate of who? Moors.
Good evening.
Good evening.
I am Gabonde Wasepe, Haji